think in film, everybody's always vying for power and control. I think that this is probably the most intense situation I've ever been in film. He was one of the few directors I've worked for that was very kind and respectful. In my opinion, I find it very hard to believe the allegations against him. And considering his mission statement about the film and him genuinely pitching that he was doing this film to help young women, I just find it hard to believe.
Sometimes, narcissistic individuals use the legal system as a weapon to intimidate or shut down criticism. This tactic often targets people who speak unfavorably about them. When the individual is a public figure, their targets may include reporters, digital creators, vloggers, and even major media organizations. The range is broad in Blake Lively's situation. Her attention is now shifted toward Justin Baldoni's legal team and, more recently, digital influencers. But why? What's the motive? My theory? Since Baldoni's case was tossed out, Wayfair's legal attention has zeroed in on one case, Von Zan Inc., Veto defendants. This case, launched in New York State Court on September 27, 2024, alleges breach of contract and reputational harm, citing third-party leaks of damaging information. Yet only one entity was subpoenaed: Jones Works. They were asked to turn over the contents of a former employee's phone, specifically Jen Abel's. That subpoena was issued on October 1, 2024. As of yesterday's court records, Ryan Reynolds claims ownership of Van San Inc. There are two Van San companies, one based in New York, the other in California. The California entity is inactive and was originally dissolved and revived by Blake in 2021. However, that business can't legally operate in California because the Franchise Tax Board revoked its status over unresolved legal issues. These include labor violations, FTC scrutiny, and marketing fraud. Blake's name is still tied to it. That business is technically a foreign entity with its base in Delaware. Meanwhile, Ryan set up a separate Van Zan Inc. in New York back in 2019, this one as a domestic company, not linked to Delaware. So now we have two Van Zans with one address but different tax details. One tied to Blake, the other to Ryan. And Ryan now claims his company subpoenaed Jones Works for Jen Abel's data. I believe the pressure is mounting because TMZ just ran a story, one that could only have come from Blake's camp, alleging she's subpoenaing three big-name creators. They believe those creators are leaking Wayfair insider info. The names? Candace Owens, Andy Signore from Popcorn Planet, and Perez Hilton. MZ ran with the story ironically. Candace has already denied getting subpoenaed. I contacted Perez. Hilton myself, he pointed me to a video where he clearly says he hasn't received any subpoena and questioned the story's credibility. He notes and he's not wrong that nobody has really been subpoenaed in months. The last batch went out back in May to Justin's legal team. Page 6 in Daily Mail. Reporters got theirs in April, but the majority of subpoenas were issued way earlier in February and March, with today being the substantial document submission deadline. Any new subpoenas would be cutting it way too close. But Blake got the headlines she wanted. And now, TMZ's floating the idea that these creators are working with Baldoni and Wayfair. This mirrors what happened with Shasti Flaw. Shasti messaged me today and asked if I'd been served. I told her no. She replied, if anyone would be, it'd be you. Then I asked her the same, and she said no as well. Despite all the accusations that Shasti is part of an orchestrated smear campaign, she has never once received a subpoena. Still, they keep requesting Wayfair-related documents tied to her name. They've tried to drag her publicly, paint her as the villain, but legally. They haven't followed through. Instead, Blake seems focused on well-known names that stir up buzz, media coverage, and public emotion. Doesn't feel random, it feels deliberate. I think she has two aims. First, to control the narrative. Second, to scare potential critics. Yes, technically, she still has time to issue subpoenas. Just because none of the creators have gotten one yet doesn't mean they're in the clear. Discovery doesn't close until August 14th. Today is just the deadline for substantial evidence. Subpoenas can still go out up until then. And with a standard 2-week compliance period, the clock isn't up yet. So technically, these creators could still be pulled into the case. By the end of July, Issuing subpoenas would pose serious problems. There simply wouldn't be enough time for recipients to properly respond, file objections, and navigate the legal procedures. Honestly, even serving one today would be cutting it to close. Should Blake proceed now? Every recipient is likely to challenge it immediately. And that raises a question. Why make a move at this point? Right now, scrutiny is mounting around the weaknesses in Blake's legal argument. Much of the public discourse, especially among digital commentators, is centered around the questionable nature of the Van Zandt lawsuit. What's coming to light is a potentially calculated misuse of the legal system by Blake and Ryan. If proven, they could face consequences for abuse of process, violating privacy laws, and could be sued or even criminally charged. They could also be sanctioned, and any key evidence might be ruled inadmissible. Her case is hanging by a thread, especially after last week when Blake claimed in court she obtained evidence via Jones' works through the Van Zandt suit. However, Jen Abel has now asserted in a motion to compel that this Van Zandt case was nothing more than a manipulative tool to sidestep protocol and gain access to sensitive information without notifying affected parties. In the U.S., subpoena recipients are entitled to object before anything is handed over. Subpoenas aren't blank checks, they have legal limits. Judges define the scope. And not all data is fair. Certain materials are privileged or protected. Already, the judge rejected Blake's earlier attempt to obtain cell phone data, deeming it an invasion of privacy. Yet, the Van Zandt subpoena requested far more extensive data than the rejected phone subpoenas. Ideally, the court will now recognize the latest subpoena is too broad and highly inappropriate, but that's just one part of the larger issue. The Van Zandt case is not the only potential vulnerability. Many factors make Blake's evidence susceptible to being tossed. This could explain her current fixation on pulling in high-profile content creators. It appears she's not just trying to gather information, but trying to discredit people discussing her lawsuit. If she can persuade the public that names like Perez, Candace, and Andy are somehow working against her with Baldoni, she can cause viewers to doubt them. Whenever they speak on the case, people will wonder if they're part of a smear campaign. This maneuver feels desperate. If Blake had proof of a coordinated defamation effort online, she would have presented it. But she hasn't. She can't show there was a viral digital attack. She can't trace it. So she's aiming at public commentators who are merely analyzing her very public lawsuit. Her goal: undermine their trustworthiness, so their commentary is dismissed. On top of this, she's likely concerned her own evidence will get thrown out, particularly following Jen's motion to compel. Under federal civil procedure rules, people whose private communications are subpoenaed must be notified so they can defend their rights. If that doesn't happen, their constitutional rights are at risk, and the resulting material may be suppressed. Jen wasn't warned that her former company would hand over all her personal data even if the data came from a business device. Stephanie, her former employer, had no legal authority to turn over that kind of material to Blake without prior notice. There's also a brewing issue about improper transfer of discovery materials. It looks like courts are now exploring how Van Zandt, Jones, and Blake communicated, likely because Blake insists she legally obtained this material. But she didn't receive it through a court-approved subpoena. Van Zandt did, using questionable means. Under federal rules, discovery materials from one case can't be reused in another case without judicial approval. Blake should have legally subpoenaed Van Zandt to receive those documents. But instead, the files were transferred to her outside the legal process, which violates basic discovery procedure. It raises concerns about the authenticity of the data. If she didn't acquire it properly, how do we verify it wasn't tampered with? How do we establish a reliable chain of custody? These are key questions. We now know that some metadata is missing, which makes it even harder to validate. If you can't confirm the evidence's origin or integrity, its credibility collapses. This opens the door to possible discovery violations. Additionally, there's the question of whether Blake used the lawsuit as a front to collect data through subpoenas and then closed it before it could be challenged. Courts generally disapprove of lawsuits that serve as evidence-gathering schemes outside the bounds of regulated discovery. Lastly, there's a very serious privacy concern. Attempts to obtain private iCloud and iMessage content. These are protected communications under federal law and raise major legal red flags. The Stored Communications Act comes into play here, along with additional federal protections, like the Federal Wiretap Act. What Blake may be fearing is possible penalties for mishandling discovery. The opposition could request that evidence be excluded due to privacy violations or lack of proper notification. They might even seek a protective order to block the further spread or usage of material that was inappropriately gathered. And if they're able to demonstrate misconduct, Blake could face legal action for things like misuse of legal procedures or breaching someone's privacy rights. That's likely why she's attempting to shift attention away from the fact that the data was gathered through questionable means. I spoke with a legal expert today and asked, what if the judge just looks past all of this? What if he doesn't see this for what it is? The response? If a judge deliberately ignored such concerns, it would be a major ethical lapse and could easily be challenged on appeal. I brought up the concern that he might rule the phone was company property, with Stephanie claiming she had full authority over it. The lawyer replied, he could say anything, even something absurd, but if he doesn't present a strong legal rationale, it won't survive appeal. Then I asked if the judge might decide there was no reasonable expectation of privacy due to ownership of the phone. The attorney said, that misses the point. Let's break that down. But the phone truly belonged to Stephanie, and if that meant no privacy existed, then why would a subpoena be needed in the first place? In federal court, a neutral third party can hand over their own data legally without needing to be compelled. But even then, the information has to be relevant to the legal claims being made. Property rights aside, how is data on that phone meant to support the idea that Van Zen Inc. suffered a contractual breach at the hands of a real, named defendant? If Stephanie truly had control over the phone, and it was legally hers to give, then a subpoena wouldn't have been necessary. But she did need one, because she was bound by NDAs. In fact, her contract with Wayfair included clauses that strictly prohibited the sharing of private company information. Even removing Jen from the equation, Stephanie still violated agreements. With Wayfair and Baldoni, by releasing data, she was legally forbidden from disclosing without court intervention. That's what the contract required, court authorization. This creates yet another red flag. Same applies to Jen Abel. Just because she used a company device doesn't entitle someone else to. Her personal content, especially in connection to a lawsuit filed by a shell company like Van Zen. Many lawyers I've consulted with agree that Wayfair should contest the dismissal order, which was issued with prejudice. Their argument? It robbed them of the chance to properly present their claims. When discovery is blocked and key evidence surfaces only after the case is thrown out, there's a strong basis for appeal. The appeals court could argue that the trial judge acted prematurely before misconduct became visible. They could say the lower court failed by not allowing discovery to fully investigate procedural abuse. One big reason the judge dismissed the case was that he believed Blake's claims were protected under litigation privilege, particularly since they were included in her CRD filing. But most of the events alleged breaches, interference, and reputational damage happened before Blake even initiated a lawsuit. The judge decided on his own that these actions didn't qualify as defamation, ever letting a jury weigh in. He also wasn't made aware of how Blake came into possession of her supposed evidence. The original concern was always that Blake had obtained private data inappropriately. Then there's the ruling that Ryan can't be held responsible for defamation simply because he's her spouse and trusted her story. But how does that explain why Ryan's own company issued a subpoena for Jen's data? His reasoning was based on a breach of contract with his firm, not with Blake. And Ryan seemed increasingly anxious about the potential fallout if the case unravels. Fearing Blake could be unmasked for filing baseless claims, she acted as though she won the moment Justin's suit was dropped, but discovery wasn't even finished. If her case had real merit, it would stand on its own without blaming Wayfair for interference. In truth, her interference appears to be the real issue. And now she's throwing accusations toward Brian Friedman and his legal team, claiming they're part of a coordinated smear effort. It's not just that she's reportedly going after Candace Perez, Andy, though that still hasn't been confirmed, but now she's aiming her legal firepower at their attorneys, alleging the firm itself played a role. In a recent filing, To the California court, which will be reviewed in a hearing within days, attorney Ellen GOP, who represents Brian Friedman's law firm, outlined that Blake Lively claims she's entitled to obtain the firm's internal documents, arguing they acted as both witness and agent in what she alleges was a coordinated smear effort. Her main support for this claim? The fact that Friedman previously represented public figures and made media comments on behalf of Wayfair affiliates, but making public statements as a lawyer doesn't give someone blanket access to confidential legal files. Blake's own legal team has spoken publicly to yet. She's not subpoenaing them. This demand seems less like legitimate discovery and more like an attempt to harass opposing counsel through an unsubstantiated theory. Under the legal precedent set in Shelton, discovery from an opposing lawyer is only allowed if the information is essential, not just possibly relevant. Citing Brian Friedman's interviews after she filed her case as evidence of retaliation is a weak foundation. Lively hasn't shown how her demands meet any of Shelton's strict criteria. First, if she wants to know what was said to content creators, she can simply subpoena them instead. That's likely why she's now focusing on influencers. Second, the materials she's asking for are confidential. She believes she deserves access to financial records because they might connect to her theory that the firm acted as an agent. But she doesn't consider the privacy and legal implications involved. She's even requesting the cell phone bills of all employees and contractors. Her argument doesn't acknowledge how burdensome and intrusive that would be for a third party. On top of that, her demands are overly vague, far-reaching, and poorly defined. In short, the legal team is asking the court to shut down Blake's attempt to access their records. That was last week's filing, and I believe this is why Blake is now pivoting back to targeting content creators, because her original plan will almost certainly be denied. If her goal is to show that influencers were being financially supported or tipped off by Wayfair insiders, she'll have to prove it from another angle. She claims that LFTC, the law firm in question, acted as her opposition's mouthpiece, coordinating public attacks on her behalf. But acting on behalf of clients is literally what attorneys do. A lawyer making public statements to support their client doesn't dissolve their right to legal confidentiality. If Blake's theory held up, any opposing lawyer could lose privilege protections just for speaking in public. That would blow up the entire framework of attorney-client privilege and protected legal strategy. What Blake is really doing here is trying to suppress any dissenting voice. She views every critic, whether legal or digital, as someone retaliating against her. Her argument about hypothetical relevance doesn't meet the legal bar for forcing discovery from opposing counsel. She hasn't even cited any legal authority directly supporting her position, instead referencing unrelated cases that don't apply, essentially. She's trying to spin the narrative that anytime someone from Wayfair, their representative, speaks publicly, it's an act of retaliation for her reporting misconduct. But litigation means that lawyers are allowed to defend their clients even publicly, especially when dealing with public figures. Her real intent now seems to be proving some kind of conspiracy between Wayfair, the law firm, and the creators. Talking about this case, she wants to show that post-lawsuit content creators were fed by Wayfair. But even if that happened, Dan, there's no proof of that tit doesn't constitute retaliation. It's also hypocritical, considering Blake herself has spoken to the media more than anyone involved on the Wayfair side. Look at the facts. Baldoni has remained silent. Jen Abel hasn't commented publicly since the CRD complaint. Melissa Nathan isn't active on social media. Sarwitz Heath, Wallace, all of them have said absolutely nothing. In contrast, Blake has made consistent, public-facing commentary. Now she's trying to claim people like Andy or Perez are being paid to attack her because she's run out of evidence for the so-called smear operation, and since her digital campaign allegations are likely to fall apart under scrutiny, she's scrambling for other angles. Her belief that she'd be able to prove retaliatory behavior based solely on third parties talking online is weak at best. She wants to claim someone bankrolled the creators, but to date, no evidence shows that's true. No one's offered me money. I don't know anyone who's been paid. People covering this case are doing so by interpreting court records and public statements. My overall impression? Blake and Ryan are spinning out, her case appears to be collapsing, and they're redirecting blame because they know the evidence they relied on is on the verge of getting tossed, and the consequences could be far more serious than they expected. So what's your take?